Considering then that it is the Philippine law that determines who are Filipino citizens and who are not, so it does not determine whether a Filipino is also an American citizen or a Chinese citizen, etc., when would the problem of dual citizenship of a Filipino arise?
Such questions would arise only from the point of view of a third state. For example, if a girl whose parents are Filipinos but who was born and has lived all her life in California, USA, is applying for scholarship in a French university, the French authorities will regard her not as a Filipino but as an American, as her California citizenship is the more effective connecting factor in determining what is her citizenship, Filipino or Californian. This is applying the theory of effective nationality, embodied in Article 5 of the Hague Convention on Conflicts of Nationality laws, which provides, within a third state, a person having more than one nationality shall be treated as he had only one, without prejudice to the application of its laws in personal matters and of any convention in force. A third state shall apply the nationalities which any such person possesses, and recognize exclusively in its territory either the nationality of the country in which he is habitually and principally a resident or the nationality of the country with which in the circumstances he appeared to be in fact mostly connected. Undoubtedly, in the above problem, California is more effective connecting factor in determining which of the girl's two nationalities or citizenship is her personal law.
If Bruno, a Filipino citizen, marries Gardo, a citizen of another country where same-sex marriage is allowed, and that Bruno is allowed to acquire Gardo's citizenship by reason of the latter's country's laws, is Gardo still considered a Filipino citizen, or must he take an oath of allegiance to retain his Filipino citizenship? Ayon sa Article 15, New Civil Code, laws relating to family rights and duties, or to the status, condition, and legal capacity of persons, or binding upon citizens of the Philippines, even though living abroad. Kaya kahit na bet natin ang hashtag #LoveWins, ang Pilipinas ay hindi pa kinikilala ang same-sex marriage. Kaya si Gardo ay hindi nawala ang pagiging Filipino citizen. Carry lang yan!
Chanelin was born on May 16, 1934 in Australia to a Filipino father and an Australian mother. In 1949, at the age of 15, she left Australia and came to settle in the Philippines, where she later married a Filipino and since then participated in the electoral process, not only as a voter but as a candidate. Will Chanelin be disqualified or not? Is she an Australian or a Filipino citizen?
The Philippine law on citizenship adheres to the principle of jus and gimi. Ngayon, ang bata ay susundin ang nationality o citizenship ng mga magulang niya kahit pa sa ang lugar ng Earth ipinanganak ang bata, kumpara sa jus soli, which determines the nationality or citizenship based kung saang lugar siya pinanganak. For example, si Chanelin ay anak ng isang Filipino father. The fact na pinanganak siya sa Australia ay hindi nangangahulugan na mawawala ang kanyang Philippine citizenship. Kung ang Australia aka Land Down Under follows the principle of jus soli, then si Chanelin ay pwedeng mag-claim na siya ay Australian citizen, making her a dual citizen. Kahit na si Chanelin ay mayroong Australian passport at alien registration certificate na nangangahulugan na siya ay Aussie, it doesn't mean na she's renouncing her Philippine citizenship. At dahil nag-file si Chanelin ng COC, she effectively renounced Australian citizenship. Boom! Pack! Dinner! Get mo!
Mr. X is a Syrian national. In 2011, a political upheaval arose between the Syrian government and the civilians. Due to the ongoing war, millions of people left as refugees seeking protection from other countries. Mr. X was one of the refugees who fled and fortunately arrived in Turkey where he met Miss Y, a Filipino nurse. Meanwhile, the insurrectionists won the civil war, successfully ousted the former government and subsequently established a new one. New laws were passed including the abolishment of previous official documents which recognized Syrian citizenship. As a result, the refugees, including Mr. X, were legally stripped of their Syrian citizenship. Mr. X and Miss Y thereafter went to the Philippines and established a new life together, despite the stateless status of Mr. X. Now, Mr. X wants to be a Filipino citizen and thereafter marry Miss Y. Can a stateless person be subsequently considered a citizen?
Ay pwedeng-pwede. Basta ang isang tao stateless ay nagtataglay ng lahat ng qualifications at wala ng mga disqualifications ayon sa batas, they can be naturalized even absent the requirement of reciprocity. Ang Pilipinas ay signatory sa ilang UN conventions and has impliedly adhered to as part of the law of the land, which had been enforced in order to address the problem of statelessness and the concern of finding asylum to refugees. Sabi ng Article 32 ng 1954 UN Convention relating to stateless person, ang mga signatory states should make an effort to expedite the naturalization proceeding of a stateless person. At kahit maladya din ng on the wings of love ang peg nila, Mr. X can go through the process of naturalization to acquire Philippine citizenship and enjoy personal and property rights afforded by law. And they can live happily ever after. #MyForever is a stateless person.